All right, this is a practice presentation for later this week. MAID state differences, present and future legal considerations. So we're here at the National Clinicians Conference on Medical Aid in Dying. Thanks for having me as a non-clinician. I'm going to talk about the law. Now, the law is, of course, only one barrier to MAID access, but it is a big one. I was delighted to be here 3 years ago at the first NCC MAID. Here I am. And since then, in the last 3 years, we've had 3 new statutes enacted, 6 lawsuits filed, and more than 50 bills. And of course, some important international developments in medical aid in dying. But today, this morning, I'm going to focus just on some really top-level headlines. And specifically, I'm going to focus on just those issues that are most relevant to clinicians. So as you know, 11 U.S. jurisdictions permit MAID. Most of those follow the 1994 Oregon model, but not exactly. There are variations from state to state. And at some level, the fact that there are now more and more variations was predictable, right? Go back all the way to 1997, when Tim Quill and Harold Glucksberg brought lawsuits seeking to establish a federal constitutional right to medical aid in dying, like we used to have for abortion. Well, their cases went to the U.S. Supreme Court, which said no, there is no right to MAID under the U.S. Constitution, right? And so since then, since 1997, we've focused on rights at the state level. But back then, in 1997, Sandra Day O'Connor said, this matter is now entrusted to the laboratory of the states. And in fact, those state laboratories have been busy. And we have a lot of variability. So what I'm going to describe for you are 9 variations among U.S. MAID laws. Variation number 1, who can prescribe? So in 10 states, it's physicians only, right? You must be an MD or DO to prescribe MAID medications. But in New Mexico, also permit an APRN or a PA to prescribe. And that approach of a broader scope of clinicians has been on the rise, right? We see bills in current MAID states like Hawaii and Washington to do the same thing as New Mexico, and we see bills in new prospective MAID states to do the same. And of course, this just fits in with a much, much broader trend of expanding the scope of practice of NPs and PAs. Okay, so that's variation number 1, who can prescribe. Variation number 2, how many clinicians does it take? Well, in 10 states, it takes at least 2, the attending plus the consulting physician. But, again, in New Mexico, it only takes 1. At least where the prescriber is a physician and the patient is already on hospice. And this approach is also on the rise. We see bills in new states like Virginia, for example. So that's variation number 2. How many clinicians does it take? Variation number 3. Who is eligible for MAID? In 10 states, you have to be a resident of that state to qualify for MAID. Now, we know that for decades, that's been relatively easy You can become, right, if you weren't already a resident, you can become a resident of that state, right? The evidence is just a driver's license, voter registration, tax return, or just own or lease property, right, which is easy. Any of us could become residents of Oregon this morning for purposes of MAID, right? And famously, of course, Brittany Menard became an Oregon resident for MAID. But we're right here at Revolution Hall in Portland, and just a couple miles north of us is Vancouver, Washington, different state. And there were patients in Vancouver whose physicians were in Oregon, right? Particularly this physician. And he brought a lawsuit saying, hey, I want to be able to provide MAID for my Washington state patients. And to prohibit that, or the law's current requirement for residency, violates the U.S. Constitution's Privileges and Immunities Clause. So now, and that lawsuit was successfully settled in favor of Dr. Gideon's, and now Oregon doesn't have a residency requirement. Residency is not required. In fact, patients from other states have come here to Oregon for medical aid in dying without becoming residents. So that's Oregon. That was the lawsuit achieved that result. And now the state legislature is following up with a bill to take the residency language out of the statute. And again, this approach on the rise, right? Very similar lawsuit is pending in Vermont, brought by a patient and physician plaintiffs. And there's a bill in Vermont to remove residency from their statute. Plus, right, if this really is a constitutional requirement, I mean, requiring residency is constitutionally prohibited, then we're going to probably eventually see the residency removed from all of the states. And in fact, some of the new bills, like in New York, don't include a residency requirement. So that's variation number 3, who is eligible. Variation 4, how long is the waiting period? In 9 states, the patient has to make 2 oral requests separated by 15 or more days. In Hawaii, of course, it's 20 days. And we know that there's a lot of evidence that shows that for many patients constitutes an undue burden, right? They can't wait that long. So 2 states shortened the waiting period. So New Mexico and California lowered it down to 48 hours. And that approach, shortening the waiting period, on the rise. Vermont lowered its waiting period from 17 to 15 days. And we see bills in current MAID states like Hawaii and Washington to shorten the waiting period. And bills in new prospective MAID states like New York, which, right, proposes only 1 request, no waiting period. So that's variation number 4. How long is the waiting period? Variation number 5, very similar, is the waiting period waivable? So in 9 states, all patients must satisfy the waiting period, no matter what that waiting period happens to be, whether it's 2 days, 15 days, 20 days. But some patients, again, can't wait that long, however long that happens to be in that state. So 2 states allow waiver of the waiting period. In Oregon and New Mexico, right, the patient is exempt from having to satisfy that waiting period if, quote, death is likely to occur before expiration of the time period. And this approach, waiving, is on the rise. You see current MAID states like Hawaii and New Jersey and Washington would make patients exempt from the waiting period in certain circumstances. And you see the same thing in prospective MAID state bills, like in Indiana and Virginia. Plus, it's worth noting in the Washington version, it goes a little bit broader and would make patients exempt from the waiting period, not only when they're not expected to survive, but also when they have intractable suffering. Okay, so that's variation number 5. Is the waiting period waivable? Variation 6. What must providers do when they object for conscience reasons? Well, in 11 states, all 11 states, right, participation is voluntary, right? But in 8 of the 11 states, though, the only duty of the objecting clinician is to transfer the records when the patient finds a new clinician. But in Vermont, they have to do a little bit more. They have to either inform the patient about this option or at least refer them to some place where they can learn about this option. And that was the result of a lawsuit. In California, the objecting physician has to document the date of the request, and that counts. Even though they're objecting to that, that counts as one of the two requests. Now, that requirement has been challenged in Los Angeles federal court. That's pending. And in New Mexico, the objecting clinician must refer the patient to a provider who is able and willing to provide MAID. And that has also been challenged, pending in federal court, as a violation of the objecting clinician's First Amendment rights. So that's variation 6, how to object for conscience reasons. Variation 7, how many capacity assessments does it take? 1, 2, or 3. In 9 states, there have to be 2 assessments, but sometimes 3, right? If the attending or consulting physician refers to a mental health specialist. Now, that rarely happens. Of course, in Hawaii, it's always 3 assessments by 3 clinicians, not contingent upon any doubts or concerns about capacity by the attending or consulting. Every patient always gets a 3rd screening. In New Mexico, it's only 1, unless there's a recent history or suspicion of a mental health disorder or intellectual disability that could cause impaired judgment. So there's this, and there's also variability in exactly who can. That's variation 7. How many capacity assessments does it take? Variation number 8. Who can do mental health assessments? In 6 states, it has to be a psychologist or psychiatrist. In 5 states, it could also be a licensed clinical social worker, clinical mental health counselor, or psychiatric nurse practitioner. And this expanding of the types of clinicians that can do this assessment is on the rise. You see this in Washington, and there's a session tomorrow on capacity and judgment evaluations. Finally, variation number 9. The approach for a long time has been legislative. State legislative has been the focus. But in the early years, we took a far heavier judicial approach. Right, we brought at least 15 cases all across the country seeking to establish a state constitutional right to MAID. And just last year, we renewed that judicial approach a little bit. Just give me 4 examples. Right, in Massachusetts, this physician brought a lawsuit seeking a state constitutional right to MAID. Unfortunately, that didn't work out. In California, a lawsuit was brought saying for patients who have certain neurological diseases that they cannot complete the self-administration because of that physical disability, then somebody else should be allowed to help the patient complete the self-administration because of the Americans with Disabilities Act. That didn't work out, although it's now pending in the U.S. Court of Appeals for the Ninth Circuit. And there's a session today on ALS and neurodegenerative diseases. On the more positive side, on lawsuits in Oregon, of course, the lawsuit did successfully challenge the residency requirement, and we have that similar case pending in Vermont. That's variation number 9, judicial versus legislative approaches to assuring access to MAID. So in conclusion, right, I've showed you 9 variations among U.S. MAID laws, and we're likely to see more this year, next year, and the year after that. Thank you.